All right. So this matter comes on in regard to request for contempt. And I just want to make sure that the items that that the parties want me to consider are in the Odyssey. The last document I have is from Mr. Torres that was filed on July 12th. So last Monday, or excuse me, Friday. And so I didn't know, Ms. Powers, if there's a responsive pleading or not.
I don't think a reply declaration is necessary. I would like to make a little bit of argument about it.
Okay. All right. So with that, counsel, go ahead.
Thank you, Your Honor. We're here on two matters today. One is our contempt motion, and the other is to review the status of evaluations that Mr. Torres was ordered to do from the guardian ad litem initial report. I'm going to start with the contempt order. Our office was forced to file a motion for contempt when Mr. Torres refused to return Ms. Wolski's personal property. Ms. Wolski moved out of the residence in September and has been trying to get her personal property since then. In November, the parties had a hearing, and the clerk notes reflect that the court ordered Ms. Wolski to work with Mr. Torres's attorney for the return of her items. She tried to do that and was unsuccessful. After she hired me, I reached out to Mr. Torres's attorney, Mr. Foley, and also tried to arrange exchange of the items. We provided list of personal property that Ms. Wolski wanted returned. Never in this process did Mr. Torres say that he did not have the items, and never in this process did Mr. Torres communicate to our office that he did not believe these items were Ms. Wolski's. Instead, we brought a motion on April 1st. Part of our motion included asking for return of her personal property. We included a copy of the list of items we were requesting. Mr. Torres, with help of counsel, Mr. Foley, filed a responsive pleading on April 25th, and in his response indicates he's set all of her property aside. He ended up agreeing to exchange it to her. The court entered an order on May 21st, 2024, indicating that the petitioner has set Ms. Wolski's personal property aside and the parties will work together through their attorneys to arrange return of the items. I worked together with Mr. Foley and we agreed for return of the items. On the appointed day, Mr. Foley delivered to my client a garbage bag full of things that were not on her list of items she wanted returned, along with an air freshener at the top of the bag that said FU. That was all that was returned. I contacted Mr. Foley after this exchange happened and got no further response from him. To date, Mr. Torres has returned nothing on the list of property, and we're coming up on almost a year since the parties separated, and the items have not been returned to her. Mr. Torres did file a responsive declaration late last week. He did not serve our office with that response, but I found it in Odyssey this morning as I was preparing for this hearing. I would note that in his declaration, he indicates that he's now contesting whether any of the items are Ms. Wolski's, and he's now claiming that she got all of her items in September. I think that this is disingenuous when you look at the history that has occurred within the court system and the communications between attorneys that have occurred since September. At no point until this declaration filed last week has Mr. Torres claimed that Ms. Wolski already received her items. Instead, he's acted like he would cooperate and return them, although he has not done so. I'd ask the court to find Mr. Torres in contempt and order that he return the list of items by July 24th, set another review hearing for July 30th to follow up on whether or not those items were returned. If they're returned, that hearing can be stricken. I'd also ask Mr. Torres be ordered to pay $1,000 in attorney fees for having had to bring this motion, along with all of the communications I had to have with Mr. Foley, trying to get this resolved outside of court. Thank you.
Mr. Torres.
First, I would like to request a continuance as I did not completely file the declaration that I'd filed. I did not serve the opposing party, mainly due to finances preventing that from happening until this week. To respond to the statements made by Ms. Powers, my attorney did not communicate to you that the items were not here and that she had claimed them already. I did communicate this to my attorney. The items I agreed to provide were the only items that were left here. I told this to my attorney. My attorney has been acting without my input. He has been acting on his own, essentially, and is no longer my attorney and has essentially ghosted me. I've been requesting information from my case to him and has not been communicating with me. So I'm requesting a continuance so that I can continue to seek legal counsel and properly file this declaration.
Ms. Powers, in regard to that request.
I would ask the court deny a continuance. Mr. Torres was personally served on June 21st. That's more than the required time under the court rules. And he's had plenty of time to respond. And this is not a new issue. We brought this up in our motion on April 1st, which he responded to. It was brought up at a hearing in November. His response is new, but our requests are not new. Essentially, at this point, I think that he's just been stalling, and I don't think he intends to return any of these items, and I'm pretty concerned about that.
So at this point, I recognize that the matter has been pending, and I understand the concern as far as the idea of how long it is taking to get items and potentially what those items are. At the same time, the court always has concern on a contempt matter when a party is not represented, and if they are seeking an attorney, then the court doesn't have at this point, I'm going to grant the continuance, and that will allow proper service of getting that pleading to your office, understanding you did pull it off of Odyssey. So I'm going to give you a very short amount of time, Mr. Torres, because this has been pending for a while, as far as when it was served on you, as well as the length of time that these items are alleged to have been withheld or not returned. So I'm looking at August 6th.
I'm available that day.
Okay, August 13. Are you available then?
Yes.
Mr. Torres, are you available then?
I can be.
Okay.
And I am available on the 6th too. So either of those dates are fine for me.
Okay. Do you have a preference, Mr. Torres, the 6th or the 13th?
No.
Okay. So why don't we go ahead with the 6th? That'll give some time, and as well as move it forward. So I'll set it to, so you are available, correct, Ms. Powers?
Yes, I am.
Okay, so we'll go ahead and set it over to August 6th. And Mr. Torres, just if you haven't been out seeking an attorney, get on top of that right away, because the matter will be going forward on that day.
I have a appointment scheduled for the 8th. Just remembered that. So would we be able to move it to the 13th?
Okay. If you have the 8th, then fine. We'll go ahead and set it to the 13th.
Thank you.
Could the court also set a date certain by which Mr. Torres has to file any additional pleadings? And I would ask to have at least a few days to reply in case that's needed.
So, Mr. Torres, there are rules that you do need to follow. I understand you're not an attorney. At the same time, there are rules that you need to follow in regard to the time of getting documents to the other party. And the Friday before is not an acceptable time frame. So you need to be aware of that. You need to look at the local rules and be familiar with those if you continue to represent yourself. And so with that, I would want you to, let's see, 8th. I would want, if you meet on the 8th, I would go ahead and have you file things by, let's see, we were on 13/10. File things by the 9th. That'll give you a short time, Ms. Powers, but it still gives you time. So it's going to be a quick turnaround as far as the date. So I would get in and see whatever attorney as quickly as possible. Okay.
And just to add to that, when I did call regarding the rules on filing and spoke with the clerk, they indicated that I just needed to file 5 days in advance, but didn't state that that was a hard rule. So my apologies for the filing.
Okay, the rules are the rules, and that doesn't sound, I don't know what they were looking at, but they don't give legal advice. So I'm not sure what you were being told. Anyhow, read the rules. Okay.
Yes.
All right. All right. Nothing further on that matter for today.
We have Ms. Powers is present. She represents Melissa Wolski. Ms. Wolski, are you on the line today?
I see her name up there. I believe that she is.
Okay. All right. Looks like she's present. Ms. Height is here. She's the guardian ad litem. Welcome to you.
Good morning, Your Honor.
Good morning. And I'll ask if Luciano Torres is on the line. All right.
Yes.
Mr. Torres, I can see that it looks like you're on the line. Can you hear me?
Yes, I can hear you.
Okay, very good. Just so you're aware, your voice came across fairly faint. And so if you could just make sure your voice is extra loud when you're speaking, that'd be appreciated. Thank you.
Okay.
Much better. Appreciate that. All right, we're on today for Ms. Wolski's motion for contempt and also just an inquiry regarding evaluations of Mr. Torres. So I'll hear from Ms. Powers regarding your motion.
Thank you, Your Honor. We're here today on Ms. Wolski's motion to find Mr. Torres in contempt for failure to return her personal property. To give a quick history, the parties separated in September 2023. Ms. Wolski brought minimal amount of stuff with her. She was able to go to the home and get a few things, but not very much. She started asking for the rest of her personal property that fall, in the fall of 2023. There was a hearing on November 21st, 2023, when Ms. Wolski brought the issue of personal property up in front of the court. The clerk's notes indicate that Ms. Wolski was supposed to work with Mr. Torres's former attorney, Mr. Foley, to work together to get her personal property returned to her. She tried to do this with no success. Ms. Wolski hired me, and in March of 2024, I started communicating with Mr. Foley about return of her items. My first email to him was March 5th. Mr. Foley requested a final list of items she was requesting, and we provided that to him March 15th. We were unable to work out return of any of her personal property. On April 1st, Ms. Wolski filed a motion which included a request for return of her personal property. The motion had attached to it the list of items she was requesting. On April 25th, Mr. Torres, through his attorney, Mr. Foley, filed a response indicating that Mr. Torres had set aside the remainder of her requested property and would return it to her. On May 21st, 2024, the court entered an order that the parties would work together through their attorneys to arrange to return Ms. Wolski's things. Mr. Foley and I reached an agreement that the parties would return the items on May 22nd during the exchange of the child. On May 22nd, Mr. Torres returned 2 bags full of clothes that the kids had already outgrown. In the top of one bag was an air freshener strategically placed that said "FU." None of the items on the list that we had provided to Mr. Foley and to the court were included in the bag. Following this exchange, I reached out to Mr. Foley to arrange a new date. No response was received. Mr. Foley has now withdrawn from the case, and we've been forced to bring this motion. It's been over almost a year since Ms. Wolski moved out. A lot of her clothes and personal property were left in the home. She had a son from another relationship. Most of his things were still in the home. Ms. Wolski's brother passed away and left her some property that was also in Mr. Torres's home. None of these items have been returned to her. To date, Mr. Torres has filed a response, and at this point, he seems to be indicating that either there's no items left or he denies that any of these items belong to Ms. Wolski. Understandably, my client's really frustrated. She's been very proactive. We've taken a lot of steps to try to get her property returned to her. At this point, we're asking the court to fine Mr. Torres in contempt, order him to pay $1,000 in attorney fees for the cost of bringing this motion, and for all of the steps we've had to take in trying to get her property back. We'd ask the court to set a date certain that her property be returned, set a follow-up hearing to review compliance. And if Mr. Torres still won't comply, then at that point, we'll be asking that the court order a civil standby so that Ms. Wolski can go to the home and retrieve her items.
Thank you. And the list that you mentioned, that's in your June 20th motion for a show cause, that has the listing of the items.
Yes, and that's the same list that had been provided with our previous motion and also by email to Mr. Foley back in March.
Okay. All right. Thank you. All right, Mr. Torres.
Yes, as stated in my declaration, Melissa took all of her property when she came with her mother to pick up her items. She loaded her mother's SUV fully. It took her about an hour to load her property that she said she left here. She also loaded her own SUV that she took with her with property. So I don't know what property is left here. I've told my attorney this. I informed Mr. Foley this, that there was no property here to give. My attorney failed to communicate this to Melissa and her attorney. The items that are returned to her, including the air freshener, were the items that Melissa left here that belonged to her. This entire process began with me simply trying to establish parentage, and here we are a year later arguing over property that doesn't even exist. I've put in my declaration the times that she came, that she picked up items and was here doing things. I don't know. I wasn't even in the home. I was outside with my kids. So I don't know how she can claim that all this property is here now that she didn't have an opportunity to get when she came to my house repeatedly up until I filed my declaration for parentage, or my request for parentage. So I don't know what property is there to give.
Thanks, Mr. Torres. I wanted to ask you a question. In your response, you included some screenshots of, a video monitoring system at the home. And it looks like on September 5th, there were a time frame from 4:17 p.m. to 5:02 p.m. And are those images of Ms. Wolski and her mother, or just the mother?
That's an image of Miss Wolski entering and exiting the property with her items, her belongings, loading up her mother's truck. Her mother's truck is in the background by the tree, parked at the curb. Her mother waited in the vehicle while she loaded her car.
Okay. And besides that date on September 5th from 4:17 p.m. to 5:02 p.m., what other days did they come to the home?
Melissa came to the home. In the declaration, I don't know if you have it in front of you, I have the dates listed as well as the timestamps.
So I'm looking at your declaration that you filed on July 12th. And I see in the declaration itself, I don't see a listing of the dates. I see the security footage from September 5th with the
should have been an email
grabs. So on attachment B, date and timestamps when Melissa came to my home by herself after September 5th. So these are, tell me what this is. When I'm looking, it says September 18th, 1:48 p.m. arrives, 2:32 p.m. leaves. Is that something you typed out?
That is the timestamps of my security footage. I can provide video and screenshots if necessary, but those are the timestamps of when she arrived and the timestamp of when she left my property.
Okay, so you typed that out.
Correct. That is an email that I sent my attorney.
Okay, all right. And then I wanted to ask you one question regarding the bags, the 2 bags of clothing. Tell me about the 2 bags of clothing in the black bags.
That's what she left here at my home. I took everything out as I was told to photograph everything, and I put it in those bags, the black bag.
Okay. So you're telling me you don't have a 70-inch TCL TV in the living room?
I have a 70-inch TCL TV in my living room that I purchased for my home, and I notified my attorney that if she wants to claim that this is her property, she needs to show proof. I have receipts for the property.
So you have that in your home, correct?
That is in my home, yes. That it
And
belongs to me, yes.
a circle mirror from Mason's room, where's that?
That does not exist. She must have taken it.
Did you take any pictures after she came to your home on repeated occasions to document the property had been taken?
No,
You've been pretty careful. You've been pretty careful to document when she came.
I might have some photos of the property when she came and took the stuff from the room, yes. I'll have to find that.
Did you submit those today?
No, I did not. I did not feel that I needed to, with the timestamps of her arriving and leaving, and as well as the timestamps of her taking her property and footage of her actually taking her property.
Well, when you look at the screenshots that you included in your declaration, let's just go to those. Show me where she's carrying property in those screenshots.
Would it be better for the court if I screenshotted an item in her hand?
I'm just asking you on the declaration and the photo submitted with the declaration.
Yes, the photo submitted, there may be.
I'll go ahead and finish my question. Go ahead and tell me where in those photos she or her mother are carrying property.
I don't have the photos in front of me. Give me a moment to go get them. Okay, I have the photos in front of me.
Great, thank you. So I'm looking at your attachment A from your declaration. You can just guide me in the order that they were presented in that declaration of the pictures in which items are being carried, and then tell me what items are being carried.
So in attachment A, first, second, third, fourth. On the 5th page, there's an item being carried. Do I need to document every single item on her list of being carried out of my home?
I'm just asking you, just tell me what you see and tell me which items are being carried.
I don't know what items she carried. I didn't monitor everything that she went through in my house. From the look of the photo screenshot, it looks like a basket of items.
Okay, so you're on which photo are you looking at?
Going back, it's attachment A.
Mm-hmm.
And that's page 1, 2, 3, 4, page 5.
Okay, and so does it show where it says front door today, 4:55 p.m.?
4:53 p.m. It looks like Melissa's carrying some items out of my home to a black SUV that belongs to her mother.
So just make sure we're on the same photo. Top left corner of the picture says 4:34 p.m. and then down below that says 6:49.
Yes, the 4:34 timestamp is the screenshot for this declaration. The 6:49 is me recording the video footage, and the 5:50 or 4:53 p.m. is the actual timestamp of when the recording occurred.
So on that photo, there's multiple timestamps. There's 1, 2, 3, 4, 5. I'm looking at the very top one. It says 4:55 p.m. Is that the same one you're looking at?
Yes.
Okay. And that's a photo of whom?
That's a photo of Melissa and her mother when she came to pick up her items on the 5th. Loaded up the full truck, completely empty. Nobody, just her and her mother, loaded the full truck.
Where's the truck?
It's behind the tree, right there in front as she's walking towards it. It's under the shadow of the tree.
Oh, it's off to the right.
Yes.
Okay.
It's a Chevy Tahoe SUV.
Okay. And so there's that image, and then what other images indicate or show people carrying property out?
I did not know that I needed to include every single image of her carrying property, but if that was the case, then I would have done that. But I have multiple screen grabs that I can grab from the video. So if you continue down the list of screenshots that I provided, there's this third, 2, If you go down 3 more pages, there's another photo of her carrying items to the truck. And the timestamp is 4:54, so that's a minute later, and she's still carrying items to this truck. 4:53, she's coming back to the door. 4:53, the door's open, so she's still loading the truck.
Okay, any other screen grabs in which property is being carried out?
I do not have any screen grabs in my declaration that have her carrying property. No, that's all that was submitted.
Okay. All right, thank you. And then you said there was a representation that you indicated with a declaration or a filing that as of April 25th, you had set property aside. Tell me just a little bit about that, how you ordered the property, where you put it when you set it aside.
What are you talking about? The 25th? There's an email, or what is it that you said? I'm sorry.
I'm not sure. I'll ask Ms. Powers if she recollects what happened on April 25th, where that information came from.
It was the declaration of Mr. Torres submitted through his attorney.
Okay, looks like there's a declaration that you submitted where you indicated the declaration was dated the 25th of April, where you indicated you'd set the personal property aside.
Yes, I told my attorney that the property that was on the list either did not belong to Melissa or did not exist here. And he informed me that I should photograph the property and send it anyway. And I kept on getting multiple lists, which is why I requested a full list, a final list. And my attorney did not communicate that I contested the ownership of some of the property on the list, but the other stuff that's on the list does not exist here. And instead of communicating that, I received a declaration stating I will return the property that was left here, and which is what I did. A bag and the air freshener was what was left here.
Okay.
And so now I'm being held in contempt of court for doing what was requested of me by the courts.
Is the ice maker, it's still at the home?
I'm sorry, what?
The ice maker?
No.
Okay. Air fryer?
Air fryer is still here, yes, but that was purchased for the home.
Okay. Sewing machines?
No.
Tapestries?
I don't even know what that is.
You don't know what a tapestry is?
No.
Did you ask your attorney what that was?
He was not very communicative. In case you can't tell, he did not communicate with me very well. I don't even know what's going on with my case for the most part.
I was just asking a question. If you asked your attorney, if you asked him what a tapestry means, if you didn't know what it meant.
Why would I ask my attorney what a tapestry meant? That would charge me $175 for asking that question and wouldn't even answer it.
Well, one might assume that if one party in litigation is asking for a particular item of property and you've indicated that you've set property aside, you'd want to make sure that if they're asking for a particular item and you have it, then you could set it aside. So it seems reasonable that you might make an inquiry.
It seems more possible that my attorney would have responded when I said, hey, this stuff does not belong here, but that didn't happen. So.
Right, but you don't know what a tapestry is, so you wouldn't know if it was at your home or not at your home. That's why I asked the question.
Okay.
A dresser from Mason's room with gold hardware, is that in the home?
Yes, but that's what Mason uses when she's here. Is she no longer allowed to have things here at my home? Okay. Is everything going to be cleared out from my home because Melissa claims it's hers when it's not?
Wooden Christmas ornaments handmade from my grandfather in Christmas tree bag. Do you still have those?
I don't even know what those are, what they look like, which is what I told my attorney, and he didn't communicate that. This was back last year that we've been going through this.
Did you look in the Christmas tree bag to see if there were wooden Christmas ornaments in there?
Yes, I put up my Christmas tree when I looked, and I didn't see it, which is what tells me that these things don't even exist here.
A silver laptop from the bedroom and a charger, is that in your home?
No.
Hunter's belongings. Any of Hunter's belongings?
What do Hunter's belongings look like?
I'm just asking you the question, Mr. Torres. Do you have any of Hunter's belongings?
I'm asking you what they look like. I don't know what they are.
Mr. Torres, I'm asking you, do you have any of Hunter's belongings in your home?
How can I answer a question you just said? If I don't know what something is, how do I know if I have it?
A simple yes or no would suffice.
I don't know. If you could describe it, or if I come across something that doesn't appear mine, it may be Hunter's.
Is there kitchen decor on the walls? Is that still on your walls in your kitchen?
No,
Jackson's toys? Do you have any of those in your home?
yes, but like I said, he's my son, and I still have another case that I'm willing to work on.
All right. Thank you, Mr. Torres, for answering my questions. Do you have any other information you'd like to share?
This completely is unbiased. This is biased. Like, that doesn't make any sense that she can claim property that doesn't even exist, and I'm being held in contempt of court for it.
Thank you. Ms. Powers?
Thank you. Just briefly in reply. First of all, Jackson is not Mr. Torres's child. That is Ms. Wolski's child from an earlier relationship.
Until the case is brought forth.
Mr. Torres, it's Ms. Powers' turn.
So all of Jackson's property should be returned to Ms. Wolski. As I've laid out for the court, Ms. Wolski began asking for her property as early as last fall. It was addressed in court in November. It was addressed with Mr. Foley directly with Ms. Wolski in the winter. It was addressed between me and Mr. Foley in March. It was addressed by motion in April. Mr. Torres, at that point in his declaration in April, agreed he had set aside the property. It wasn't until we get to July, after we filed for contempt, that Mr. Torres is finally saying he contests ownership of the property and doesn't have anything else to return. I think it's pretty clear that Mr. Torres is choosing not to return items, and we ask that he be found in contempt and that the property be returned to my client.
Thank you. Ms. Height, do you have any input?
Not on this matter, Your Honor. Thank you.
Thank you. Mr. Torres, it sounded like you had something that you wanted to share.
It doesn't matter. It's not going to make a difference.
I'll make a finding of contempt. There are three specific items on the list that Mr. Torres indicated that he has them and he's refusing to return them. In particular, Jackson's items, the air fryer and the dresser with the gold hardware. I'll impose $1,000 of attorney fees, a $100 civil contempt fine, and we'll set a review date to make sure that all the items in the list are returned. Today is the 13th of August. We'll come back on the 27th of August at 9 o'clock in the morning to make sure that those items have been turned over. If they haven't, then we'll set a date where we can have the police out there and go through the home and retrieve the items.
Your Honor, I'm
Yes,
sorry to interrupt. I'm not available on the 27th, but it may not be necessary for me to appear. I just wanted Your Honor to know that.
Thank you. Appreciate that. Ms. Powers, do you have any conflict with the 27th?
I don't have a conflict. I don't have a calendar in front of me. I would ask that this be in front of you for review. So I don't know whether you were putting this on the Tuesday docket or the Wednesday docket.
Yeah, if it's in front of me, it's going to be on the 28th. So Wednesday, the 28th at 9 a.m. Mr. Torres, are you available on the 28th of August at 9 a.m.?
No, I have my evaluation that I need to go take.
Who's that evaluation scheduled with?
Whatever doctor that was hard to get a hold of that you guys laughed about. I'm sure you remember, you and Foley were laughing. What was it? Dr. Johnson takes a long time to answer his phone and hard to get a hold of and schedule. Yeah, that guy.
Okay. So we'll set the review for September 4th at 9 a.m. Does that work for everybody?
That's fine.
Mr. Torres?
It's going to work for me regardless of whether or not I agree.
As I just indicated, there's flexibility. You said you weren't available on the 28th, so we made accommodations for you. So does September 4th work for you?
Yeah, that'll work.
Okay, we'll see everybody then.
Okay, and then I just ask that Mr. Torres contact our office to arrange return of the items prior to September 4th.
All right, Mr. Torres, you'll need to contact Ms. Powers' office no later than August 16th, 4 p.m. to arrange a date in which the property can be retrieved.
Okay.
And then, Ms. Powers, as far as a presentation of that contempt.
But before we continue, I'm sorry to interrupt.
Go ahead.
Who's going to pick up the property and where is it going to be exchanged? I want to address that now in front of the court.
Yeah, that would be one item that the parties could work out when discussing it over the phone, but if
Okay, that's fine. We can work it out.
Okay. Okay, sounds good. Then as far as presentation of the contempt order from today's ruling, we generally set those for Fridays. Or actually, we can set it for a Wednesday, probably. Wednesday at 9 a.m. is probably a better date and time. Although Friday at 8:45 is an option. Any preference, Ms. Powers or Mr. Torres?
And no preference.
Okay, Mr. Torres, any preference?
No.
Okay. Let's set the presentation for the, let's see, let me just double check one date.
I believe I have another matter in front of you on the pro se docket on August 21st. If we could we just leave it there?
Okay. So we're looking at setting a date for the presentation of the contempt order, basically a summary of what happened here today. Ms. Powers would draft that. She would send a copy to Mr. Torres. Mr. Torres, if you feel that she accurately reflects what the court ordered here today, you could sign off on it and submit it to the court for signature. If you feel that she has gotten it wrong in some way, then we'd be here on the 21st and you could express your disagreement and we can sort that out. So August 21st at 9 o'clock, are you available, Mr. Torres?
August 21st at 9 o'clock. Let me take a look.
Thanks.
Yeah, I can be available on the 21st at 9 o'clock. I'll have to move around some meetings, but it should be fine.
That's great. Thank you. We'll see everybody on the 21st at 9 a.m. for the presentation, and then we'll have the review on the 4th of September at 9 a.m. And then the review, the deadline for Mr. Torres to contact Ms. Powers' office will be this Friday prior to 4 p.m. Thanks,
Thank you,
everybody.
Your Honor.
That'll conclude the matter.
Before we conclude the matter, this was actually on for two other things. We were supposed to review the GAL reimbursement and also review Mr. Torres's compliance with the 3 evaluations he was ordered to complete.
Okay. Ms. Height, do you want to address the reimbursement? Any information you care to share?
I am still waiting for $2,200 of payment. He's made a partial payment, and we had an agreement, and then he had some other expenses come up, and he has not yet been able to pay. I've been in contact with him, but haven't heard anything specifically back. Along with that, I have used my hours, but I'm not going. We don't have any final dates for this particular case, so I won't be able to complete it until he has completed his evaluations and I've heard back from the evaluators. So while I obviously want to be paid correctly, I could certainly allow some time for that to happen.
Yeah, with the evaluations, and that might take a little bit longer, right?
Yeah, I think having a deadline would be good, but it doesn't have to be like within the next 10 days or anything.
Okay. And so you indicated $2,200 is outstanding.
Correct.
From both parties or just one?
Just from Mr. Torres.
Okay. All right. Thank you. Mr. Torres, any updates as far as the GAL fee?
I sent her an email and we'll be working out some kind of payment, I believe. I'm having to save up money to do the evaluations first, since those are court ordered and those are what are preventing me from seeing my children.
Okay. Have you paid all those evaluations at this point?
No,
Which ones have you paid?
none.
Okay. And what's your plan as far as paying the GAL fee?
I plan to make a payment monthly until it's paid down.
Okay. And did you and Ms. Height talk about that arrangement?
I sent an email, but I don't believe I received a response confirming it, so I'll need to confirm with her.
Yeah, I have not received any email about payments.
When did you send it, Mr. Torres?
I believe it would have been a few days ago. Basically, I was stating that I can commit to paying $100 a month until these evaluations are done, but my priority is going to be for paying these evaluations, since that's what's preventing me from seeing my kids.
Okay. If you want to take a moment right now and go into your sent email and just go ahead and forward that to Ms. Height, I'll wait and we'll make sure Ms. Height gets that.
Okay.
We've been able to locate the email, Mr. Torres.
Yes, I'm just signing into my email right now. Looking for it now. It was sent August 8th. I'm re-forwarding it now. It's sent.
Thank you, Mr. Torres.
Your Honor, could Mr. Torres give us an update on where he's at with the DV evaluation, the SUD eval? And then in terms of Dr. Johnson's psychosexual evaluation, Dr. Johnson has contacted our office and we've provided him copies of pleadings from the case.
Okay. Thanks, Mr. Torres. Update. It sounds like you said that you have your appointment with Dr. Johnson on the 28th of August. Is that accurate?
That is correct.
Okay.
Assuming I can pay the fee for the evaluation.
Okay. And where do you stand with the domestic violence and the substance use disorder evaluations?
Substance use disorder has been completed. I believe Anne stated that there was no treatment recommended, but more to come on the report or something. And then the domestic violence, it's been a phone tag with them, so I'll need to probably just show up in person to make an appointment. A lot of these places don't seem to answer their phone for some reason.
Okay. When did you complete the SUD evaluation?
I don't remember the exact date, probably the 7th or something, maybe.
Of this month?
Let me see. I have it in email to Anne. It was, I don't remember the exact date, but it was a few days, I think, after the end of the month.
Your Honor,
Yes, Ms. Height.
I have a copy of Callett's Family Health document about his SUD, which they state was completed on July 25th.
25th, there you go.
But there was no collateral information. Their report is based solely on patient report. So I notified Ms. Wolski that she needs to participate. I don't know if that's been done. So I have an initial report that was completed, but we just need another piece to put in that.
Thanks. Ms. Powers, do you know if your client had provided any collateral input into that evaluation?
I don't know, and I wasn't given any notice that an evaluation had been done or completed. I'd ask that the results be sent to my office as well. And I will ask Ms. Wolski to contact the evaluator to provide her collateral contact.
Okay. Mr. Torres, would you be in a position to forward the report from the evaluative report from a family health center to the guardian ad litem and also Ms. Powers?
I never received the report.
Will you obtain that report and then forward that to the guardian ad litem and to Ms. Powers?
Will they release it to me? They didn't release the drug screening results to me.
It's
Even
your
though I paid for it.
evaluation. I think you can request it, and then if you need to sign any releases, you can sign those, and then you can obtain those and then forward it to the guardian ad litem and Ms. Powers.
I'll make a request and see if they give it to me.
I'll set a deadline, and it'll be received by Ms. Height and Ms. Powers no later than August
What was
20th.
the reason for signing the release of information?
I'm just saying that may be one of their requirements. I don't know if that's the case or not.
Well, so now I have to go follow through and provide Amy and Anne with the documentation that they were given rights to request themselves.
That's correct.
Why? Why can't they request it? Why am I having to be the one to request it for them?
It's your report. You're in the best position to request that with minimal effort.
That's not the case with the drug screening, is what I was saying. But they have an actual release form for the information. So now I have to take time out of my day
That's
to go
correct.
request this form.
That's correct.
Okay.
August 23rd, it'll need to be in the hands of Ms. Height and Ms. Powers.
Okay.
And just be aware that if there's not collateral input on the evaluation, it may need to be redone. Just a heads up on that.
So I just continually be charged for these evaluations until somebody decides it's enough is enough.
Just a heads up, Mr. Torres, that if there's not collateral input on the evaluation, you may have to redo it.
So essentially I can continue to be charged for this indefinitely is what you're saying.
Just giving you a heads up, when evaluations are done, self-reporting is important, and having a broader picture through collateral input. Generally, fills in more of the picture and is generally more reliable. So as a result, the domestic violence evaluation, the SUD evaluation, all require collateral input.
So then why doesn't she provide the collateral input first so that when I get there, it's already there?
When Dr. Johnson completes his report, you'll need to supply a copy of that to Ms. Powers and also Ms. Height.
Okay.
Any other items, Ms. Powers?
No, I would just point out that the order entered by the court on June 28th, 2024, that requires each of these evaluations specifies that each evaluation must have collateral input from both Ms. Wolski and also from the guardian ad litem.
So why not have her submit that before I go?
Does that sound familiar to Mr. Wolski, that the court ordered on June 28th that you have to undergo an SUD evaluation with collateral input from not only Ms. Wolski, but the guardian ad litem?
It's Mr. Torres, not Mr. Wolski.
Pardon my error, Mr. Torres.
Thank you.
Do you want to answer my question now?
What was your question? I was thrown off by the error of...
June 28th, you were ordered to undergo an SUD evaluation with collateral input from Ms. Wolski and the guardian ad litem. Do you recall that?
Yes.
And did you inform the evaluator of that requirement?
Yeah, I did, which is why I signed a release of information form so that Amy and Anne could get that information.
Okay. So the same guidance that I indicated before, that if the SUD evaluation does not include collateral input, it may need to be redone. It needs to be redone.
Cool. So I'll just basically wait until the collateral input is submitted then, or what should I do?
You figure it out, Mr. Torres. You're an intelligent man and you like to argue, so you figure it out yourself and comply with the court order.
Great.
Okay. Anything else, Ms. Powers?
Nothing further, Your Honor.
Ms. Hyde?
No, Your Honor, thank you.
Mr. Torres, anything else?
I'll figure it out.
Good for you. Take care.
You too.
Thank you.
What date are we coming back on that? What's the first date?
We are coming back for presentation August 21st at 9 a.m.
Just gonna put a little note to myself. Is here representing Ms. Wolski. And Mr. Torres, are you on the line? I saw Mr. Torres coming, and I saw multiple times. I admitted him into the Zoom room multiple times. Like apparently he was in, and then he would drop off, and then he'd come back in. So I'm not seeing Mr. Torres on the line. Mr. Torres, again, if you're on the line, please state your name. Make sure you're unmuted so I know you're present. I'm just looking at the participant list. I'm not seeing anybody with an L, first name starting with an L, because it listed in alphabetical order, and Torres, I'm not seeing that either. Oh, here he is. Looks like he's trying to admit. So I'm going to click on admit him, and we'll see if he comes Torres, in. I think you're on the call, but I'm not hearing you. Okay. So Mr. Torres, it looks like you're muted.
Hello.
Are you there, Mr. Torres?
Yeah, sorry, I'm having internet connectivity issues today. It seems to be dropping the Zoom meeting for some reason, but are you able to hear me now?
Okay, great. Very good. Thank you. We're here today for presentation from the order that was entered verbally at our last hearing. I have a proposed order that's been prepared by Ms. Wolski, by Ms. Wolski via Ms. Powers. Mr. Torres, did you receive a copy of that proposed order?
Yes, I did.
All right. Do you have any objections to that order as being representative of what the court ordered on that at that hearing?
Yes, I do.
Okay, go ahead and tell me what those are.
Page 3, section 11, it states returns the items on the list field as exhibit E. Looking at the hearing minutes from the 13th, it states I'm to return 3 items specifically.
So you're referring to the hearing that was on August 13th, and you're making reference to the clerk's minutes?
Yes.
Okay, and then tell me which page you're looking at and where on the page, roughly middle, top, bottom.
I don't have the minutes in front of me, but I can give you the verbiage. I believe it said court rulings finds items to be returned. I believe it was the dresser. The
air fryer.
Yes.
And it says Jackson's items. So it says 3 specific Court finds petitioner in contempt. 3 specific items are to be returned to Ms. Wolski, including Jackson's items, air fryer, and dresser with gold hardware. Okay, so that's in reference to the proposed contempt order, paragraph 11, that makes reference to the June 20th attachment E.
Your Honor, could you give some more clarification on this? Because during the hearing, the court was going through the list asking Mr. Torres if he had these items. There were several items that the court came to that Mr. Torres indicated he didn't even know what the item was. My understanding of your ruling is that he was to return every item that he still had on this list. The court had just found specifically that he had these 3 items and agreed they were Ms. Wolski's, but that there were potentially additional items on this list that he still had because the court didn't talk through the entire list with Mr. Torres. Mr. Torres has contacted our office and we've arranged for return of the items to Ms. Wolski this Saturday at noon. In communicating with Mr. Torres, he will only confirm that he will have the dresser available for Ms. Wolski to pick up, not any of the other items on the list. So I know we've got a review hearing set after the items are exchanged, but it would be very helpful if the court would be clear about what they expect Mr. Torres to return to purge this contempt.
Okay. Thanks. I appreciate both parties' input. So the clerk's minutes that reference the 3 specific items, those are the 3 items that serve as the basis or the foundation of the finding of contempt. So there is a contempt motion brought for non-return of items. There were at least 3 specific items that form the basis of the finding of contempt. I do find that the attachment E, all those items should be returned. So that should be clear that all those items are to be expected to be returned when the parties make that exchange. Any other objections to that proposed order, Mr. Torres?
No.
All right, I will sign off on that, and we will have the next review on September 4th at 9 a.m. I see Ms. Powers is here representing Ms. Wolski. Ms. Height is here as the guardian ad litem, and I'll ask if Mr. Luciano Torres is on the line.
Yes, I'm here.
Welcome to you, Mr. Torres. Right. I had 2 items that were appeared to be at issue or to discuss today. One is the review of a guardian ad litem payment reimbursement. I have a question about that. And then also is a review to check on the return of the property. Maybe we could first start with you, Ms. Height.
Thank you, Your Honor. I did have an email exchange with Mr. Torres, and we've come to kind of a gentleman's agreement of some payments that have been agreed to, the first of which will be later this month, and then 2 more in the next 2 months. And he felt like he could manage those. He's had some extra expenses, and it feels like something that's going to work for him and will work for me as well.
Okay, very good. Mr. Torres, do you agree with that rendition?
Yes.
Okay, all right, very good. All right, thank you both for that. I appreciate that. We'll hear from Ms. Powers.
Thank you, Your Honor. The property exchange happened, but there were several items missing. My client went through and told me the items that are most important to her. I apologize that I did not get a declaration filed, and I'd ask for leeway to just go over. There are 7 items that were not returned that are very important to her. There were a lot more than 7 that weren't returned, but these are the 7 that are just very important that she can't live without. So if I could go through those 7 items quick, what I'm hoping is that Mr. Torres and I can set a transfer date for these last 7 items and set one last review hearing to make sure these items are transferred.
Okay, I'll hear from you.
Thank you. The first items on the list are sewing machine. Ms. Wolski had 2 sewing machines in the home. One of them was her own, and one of them belonged to her sister and had been in their family for over 33 years. Her mom had passed it down to her sister, and her sister would like it returned. So we'd like those sewing machines returned. The second item is a picture that was in Mason's bedroom. It's a t-shirt of a Dalmatian that was framed. The Dalmatian t-shirt is very important as it was Miss Wolski's brother, Hunter, died. And when he died, he had left that Dalmatian shirt to Mason. And so we would like that Dalmatian shirt returned. It has great sentimental value for my client as well as for Mason. Additionally, there's 4 to 5 handmade wooden ornaments that Miss Wolski's grandfather made. He was a woodworker, and he sent those ornaments to her. She had left them in a red Christmas tree bag in the garage. That's where she last saw them. The next items are actually, she has some of her brother Hunter's ashes that she wants returned to her. Those ashes were in a small box on the built-in shelf in the living room, and the ashes are in a necklace shaped as an hourglass inside of a bag in the box. Along with Hunter's ashes, Hunter left her a large pink vase and a banana nut candle. She would also like those returned. And then the last item was her brother Hunter left a white MMA first place competition winning belt to her son Jackson, and it was signed with Hunter's name on the belt. So that would be the last item that she wants returned.
Okay. Thank you. Mr. Torres?
Yes.
Any input on those items that were listed by Ms. Powers?
All of Melissa's items were taken when she picked them up on, I believe it was the 5th of last year. In my declaration, I made that statement. So the remaining items that I gave her were the items that I believed were mine, but you told me were not. So I don't know what other property you want me to give if I don't have it.
So the ashes of her brother that were in a small box and a necklace, do you know about that?
No, I told you I don't have any of these things that she claims I have.
The vase and the candle from the deceased brother?
No,
Okay, and the belt?
no,
And what about the picture with the t-shirt with the Dalmatian on it?
I do not have any of these items that Amy stated in my possession.
Okay. Do you remember seeing that picture with the t-shirt with the Dalmatian on it?
Yes, I remember she took it when she took all of her stuff. So
Okay.
that's why I don't understand why I'm being accused of having these things when she clearly took them.
All right. And any sewing machines in your home? That
You've asked repeatedly and I've already answered it. Yes, I do not have them in my home. I don't have these things in my home.
Okay, that's the first time I've asked you about sewing machines. It's not a repeat question.
Today is the first time you've asked me about sewing machines. The last hearing, you asked me about those sewing machines and I told you I do not have them.
All right. Ms. Powers?
Well, I'm really concerned at this point because my client has consistently been asking for these items. When we had the contempt hearing, Mr. Torres indicated he didn't know what items had been left by Hunter. These are the items, and all 7 of these items are things that are irreplaceable and of emotional value. As you look at the history throughout the case, both in the pleadings and as reflected in the interim GAL report, there's a strong history of domestic violence here. And I'm very concerned that all of the very sentimental items are suddenly missing. My client has been diligent in trying to get these items returned and would not have requested them if she had them. A particular concern, of course, are Hunter's ashes, as those, I mean, all of these items are things she cannot replace.
All right. So obviously, any items of sentimentality and emotional connection to people who have passed or family members are of great import. And it very well may be, as Ms. Powers describes, it's a continuing flexing of power and control. It may be that, and it may be that Mr. Torres simply does not have them. So the next step that we would look at was a potential search of the home. I'm not going to order that at this time. You kind of hope that better natures would prevail, and maybe they are, maybe they're not. Maybe that power and control is flexing. I'm not sure. So at this point, I don't know what to do unless there's a particular request for action.
The courts just stated they won't do a search of the home. Would it be possible to have law enforcement accompany and not do a search, but just she knows where the items had been and just do a quick walkthrough and see, can we just grab the ashes off the box in the fireplace off in the living room? I guess I'm not sure what the right remedy is either. But it doesn't feel right to just leave it with nothing here.
So your request would be a civil standby where there'd be a time arranged. Law enforcement would arrive with Ms. Wolski. Ms. Wolski would go to those specific locations where she thinks those items are and search for them. And if she finds them, then that she would take them with her.
That would be our request. She's been out of the home since last September, so I don't know the odds that these items are even where they had been when she left in September. So I don't know if that makes a lot of sense. But I hate the idea that these items are potentially just sitting in his home, potentially.
Yeah. Mr. Torres, do you have any comment?
What would be the reason for me keeping these items?
Ms. Powers?
Well, I would say when you look at his actions, what has been his reason to keep any of these items so far? We've had to jump through so many hoops just
I
to
can
get
answer that.
any property
So
returned.
I'll allow Ms. Powers to finish. Go ahead, Ms. Powers.
To get any property returned from Mr. Torres. I don't know why he's kept it all along, but we've had the court address this in November. We've had communications between Ms. Wolski and Mr. Torres's former attorney before she hired me. We had me communicating with Mr. Torres's attorney. We had me bringing another motion. We had the court making an order. We had me and Mr. Torres's other attorney arranging exchange of the property, and Mr. Torres didn't exchange most of the property at that point. We had a contempt motion, and then we had another set where we've exchanged property, and now we've got another review hearing. We've had to go through all of these steps just to get what has been returned, which he had chosen to hold on to since September. So I don't know why he would do this beyond just control, but I believe that he is doing that. And he had told the court previously that he didn't have anything, and yet he turned over several items at our last exchange just a couple weeks ago. So he clearly had those items this whole time period. And if he had those items, why would he not also potentially have these items? Especially because if you look at the list, these are the most sentimental valued items on the entire list that she's requested this entire time. And he's had this complete list since March.
Thanks, Mr. Torres.
So prior to October 18th, 2023, when Melissa was served, my petition for custody parentage, we were discussing co-parenting with both of our kids, Mason and Jackson. Even though Amy says he's not mine, Melissa believed he was mine as well up until October 18th, 2023. So in those discussions, we discussed co-parenting. She tried to get me to pay for her apartment and pay her child support. I wanted to go through the courts, so here we are. In those discussions, she chose to leave the dresser, Mason's dresser, here because we were going to be co-parenting. She chose to leave the air fryer here because we were going to be co-parenting. And she made the choice to leave Jackson's toys. Not all of them. She took some of them, quite a bit actually, some from the back, quite a bit from his room, some from the other rooms as well. But the point is, these were agreed prior to October 18, 2023. So that's why they were here. No discussion was made outside of that. I haven't really had any contact with Melissa since October 18, 2023. The items that are stated that are left here, why would she leave them here if she was abused so badly? Why would she leave them here and continue to be at my house, visiting me, having dinner with the kids, if she had no intention of co-parenting leading up to October 18th, 2023? So my statement is the reason these items were here is because, one, we agreed to keep them here. Melissa agreed up until October 18th, 2023, to keep them here to co-parent with me. So that's why Jackson's toys and Mason's dresser were here. The TV was mine up until she decided it wasn't. The air fryer was, as I stated, was left here as the plan originally was to co-parent. So that's why those things are here. And I don't understand why I'm being accused of having items in my home that, what do I need them for? I don't have a purpose for them, right? So why would I keep them?
This case has presented itself with power and control dynamics that are pretty strong and quite noticeable. The rationale that is put forward that for the reason the items have not been returned is that Mr. Torres is continuing to exert power and control over items which are most clear or most dear and close to a person's heart, items connected to a family member who has passed. That would make a lot of sense for somebody who's trying to exercise power and control. The items that are missing, I don't see any good reason why Ms. Wolski would spend money for an attorney to go after items if she had them in her possession. Mr. Torres may have gotten rid of those items in spite, or he may not have them. I'm not sure. The concerning part is that there's this balance that I'm trying to strike of utilizing the power of the state to search a person's home when hopefully the better natures of humanity would express themselves. And if those items are retained, and maybe, I don't know, Mr. Torres isn't at a point, if he does have them, he's not at a point in his life where he can relinquish those. Hopefully he can in the future, but at this point, I'm not sure exactly if I have much authority other than doing a civil standby, which is problematic because it's been many months since those items were seen in particular locations, and to allow for kind of a wholesale opening up of his home and would be problematic not only for the time constraints but for privacy issues. And notwithstanding, I think what is a pretty clear indication of power and control that Mr. Torres is exerting at this point in time, I'm going to refrain from taking any additional action and just hope that Mr. Torres, if he does have them, that his better nature will come to the forefront at some point.
Okay, thank you.
08, the Culver and
That'll conclude the hearing.
Joplin
Thanks.
matter.
That matter is ready. Curly Bliss on behalf of Jamie Culver.
Anyone else present?
Terry, hi.
Try the Corey guardian ad litem.
And when I looked in here, and I don't know if I was just, I don't believe I was missing it, but is there any report that's been filed?
There is not, Your Honor. When the interim report was assigned, the court indicated that it was okay to do a verbal interim with a email to the attorney beforehand, which I did do.
And I did receive that.
So generally that also goes to the judge. Did you send it to me as well?
So I was unclear. We've kind of been told that we shouldn't send things directly to the judges, and I honestly did not know what to do with it. If you could clarify, that would be appreciated.
We need, I want to see something in writing. So it's going to be by email. Then as long as you are sending to all the parties as well as the judge, you should be okay on sending a report. The other option is to do a quick type it up and file it with the court and do a bench copy. That works as well. What they're talking about that you shouldn't send things to the judges is we can't have ex parte contact. So as far as the idea of just sending things without copying the parties. We don't, email isn't the best way of doing things at times, but when it comes to something like this, yes, because I haven't read it, I don't have a clue what it says. So
Okay.
assume there wasn't any report.
So Judge, if you don't mind, if we want to set this matter over, that way Your Honor has the opportunity to review, I can just note my review of Ms. Corey's interim report. She didn't recommend any changes and there wasn't a whole lot to report. I can obviously let her speak to that, but I believe that she just recently had contact with mom. It might make some sense to set this matter over so she can continue to have some contact with mom and see what the likelihood of getting that final report entered in on time, and maybe we can address that at a future hearing as well.
Okay. All right, Ms. Joplin, or does that sound okay to you?
Yeah, it does. I just really want to see my little one. So whatever we can do, I would just like to do it so I can see them.
Okay. So I think, if that's essentially, Ms. Corey, if that's what you're saying is that it's essentially not recommending anything as any changes as Ms. Bliss has indicated, then we could go ahead and set it over to the 30th. And would that be enough time, or we could set it over further?
And Your Honor, I'm actually scheduled to be out of the office on the 30th, so I would request the 6th if we're going to set it over.
All right, so
I don't want to send anything over. Why do we have to send? We can't. Why do we have to keep sending pushing everything off so much?
Joplin, I'm having a hard time understanding what you're saying.
Sorry. Cool.
Go ahead and repeat.
Can you hear me now?
Yeah.
There you go.
How come we have to keep putting everything over and we can't just kind of like get it on, like all the good fun all done with? Because I don't want to push this off anymore. I really want to see Vincent more than anything, and I just don't want to keep just pushing it off.
Well, I understand you may not like continuances, and I get that you want what you're wanting to see. At the same time, it takes time. And at this point, one, I didn't receive the report, so that's an issue. Secondly, my understanding is the report is recommending no real change at this point. So that's the second thing. And so this is for looking at it further to see how much time Ms. Corey, and correct me if I'm wrong, Ms. Corey, this is so you have more time to talk to Ms. Joplin, is that correct?
Well, thus far, Ms. Joplin has not been very cooperative. I have not received payment, and I just Friday received her completed intake that she's had for well over a month. And if she's not cooperating with me, I can't move any faster.
So
I wasn't trying to be uncooperative. There was a lot of different issues with the paperwork.
Joplin, stop for a minute, please. Yep.
I'm sorry.
Your Honor.
Hold on, please, for just 1 second.
Apologies.
All right. All right. So anyhow, so bottom line, I am going to set it over. Ms. Joplin, you need to be timely. One, you need to make your payment. It's a court-ordered payment that you need to make. So you need to get it paid to Ms. Corey right away. Secondly, when she reaches out to you, you need to respond, and you need to do it quickly. Not, you're not wanting to continue the case and you just want what you're wanting, but there's a process that needs to occur, and so it's going to take time. But I need to be responsive. So with that, I'm looking at August 6th.
That works for me, Judge.
Ms. Joplin, does that work for you for a date?
Preferably not, but I will do what I got to do. And I have a question on what kind of evidence did James present to show that he needed a restraining order on me? Because I don't know.
I'm not even going to go there. The only question right now is whether or not August 6th works.
Okay. Yeah.
Okay. Ms. Corey, does that work for you?
It does.
So I'm going to set this matter over to August 6th, and Ms. Joplin, when Ms. Corey contacts you, reach out, but get that payment to her right away.
Yeah, for sure. But I still would like to know how to find out what evidence he presented to show the restraining order stuff. Because I don't know what it was, and I'm confused on how he was able to get that on me when I'm not doing anything.
Maybe you need to reach out to Ms. Bliss, but I'm not going to take the time right now to go.
Okay. All right, cool. She says she won't talk to me, but that's fine.
Ms. Joplin, call my office after court today. I'd be happy to speak with you.
All right, thank you.
Thank you. Thanks, Judge.
All right. So, all right. Do we have Mr. Jackson online?
Yes.
Okay. So this is pre-trial, which is, I will just be giving you kind of a rundown of some basic things that you need to do prior to trial. First off, you'll have a readiness that is coming up, a date, I don't know, let's see, like 23rd. 23rd. What time are those at?
11.
At 11:30. So you have a readiness coming up for purpose of finding out what exact date and time your trial is going to be set. Meanwhile, you need to be prepared for trial. So if you go to, I'm going to give you the website if you don't know what it is. It's Cowlitz Superior Court. On that page, you're going to see a couple of things that would be of help for you. One is an article for self-represented litigants, which is 10 steps for presenting evidence in court. So that's one thing you want to read and be familiar with. But meanwhile, the item that's going to give you more information as far as trial readiness is a family law trial readiness checklist for pro se, meaning self-represented. And it's a list of suggestions as to what may apply to your case. Every case is different, so not everything applies. And you'll be able to click on things that will tell you that, or get you to the forms that you need to use. So if you just look at that list of items that you will probably want to have available to you. Now, understand, if you are going to use something at trial, let's say it's a deed to the house, make sure that a copy of that is provided to the other side, as well as that there is let me back up for a minute. There's a copy that you'll use for purposes of evidence, and then you need a copy for you, a copy for the other party, and a copy for the judge.
Okay.
Okay, so make sure that you have the copies of everything. And so when you go through this list, just keep that in mind. Okay?
Yes.
All right. So that's just a real broad overview of what you need to have for time of trial. Prepare any questions that you may have for the other party. If you are going to call witnesses, you should have a witness list. And that witness list should also be provided to the other party so they know who you're going to call as a witness.
Okay.
Okay. So I can't think of anything else at this time, but read that article. That's going to help you as far as presenting evidence. And then read that readiness checklist so you know which documents you need to have and some suggestions as far as items you should be prepared with.
So that by next week for the readiness?
No, this is for the time of trial.
Okay.
So readiness is strictly about getting your date and time of your trial.
Okay.
Okay, are there any questions? Mr. Jackson, any questions?
No.
Miss Jackson, any questions?
I just have a question, if it would be to close the trial or to put him in contempt again.
That you'll need to seek legal
Okay.
help. Okay,
Okay.
all right. So, you know, you can always go online. There are other things online that are self-help for a pro se dissolution trial. So you can always try that too. So not everything is on our website, but just some things that can help you.
Okay.
Okay,
Okay.
all right. That's it for today.
Thank you.
We're on for presentation, Your Honor. We had been working together to try and come to an agreed form. There was only one issue left remaining earlier this week, end of last week. So we did submit our proposed to the court in hopes we could address. I think the only issue left is, if that's correct, Ms. Holder, was section 4B limitations.
Correct.
Is that correct?
That is correct.
Your Honor, in the hearing, and the clerk's minutes reflect, the children should not be around my client's family. The specific request made was for his mother, Anita, and father, Vance. That's what the argument was about. I took Your Honor saying family colloquially to refer to the two named individuals, so I named them specifically in the limitation. I think Ms. Holder would want it to say family in general. In an attempt to alleviate the concern, because the issue for this family members, in particular Anita and Vance, is that there are felony convictions, we did add a section that wasn't specifically in Your Honor's ruling that children shouldn't be around persons with felony convictions as a way to sort of be a catch-all if there's other concerned individuals. And that applies for both sides. But I think this reflects what the argument was really regarding as far as the two named family and not all family. That's the only issue.
Ms. Holder?
I agree with Mr. Baldwin.
Okay. So it was in regard to those two individuals. I want to say the grandparents. At the moment, I'm not quite sure. I think that's who they were.
That's correct, Your Honor.
And so it was grandparents. And so that's really what I was focused on. But I do like that language clarifying in regard to the felonies. I don't remember or recall anything specific to other family members. So a broad statement of family in general, I don't think would probably be appropriate. But the idea of no individual with felony convictions would be okay.
There should be an order for Your Honor there. If for some reason you don't have it, we'll send another copy. But we did send it over, a bench copy for signature as well as a filed proposed.
So I did receive it this morning, and it's signed by Mr. Baldwin. Ms. Holder, are you okay to approve via Zoom?
Yes, Your Honor, I am.
All right, I've signed off on the temporary parenting plan.
Thank you, Judge. One thing we did address last week also, a GAL was appointed, but respondent had not filed the financial declaration. She filed one, I think, on Monday. We haven't had a chance to review it or respond for any argument on support that was sort of held over. But I would propose that based on that, the incomes on her statement, at the very least, is less than full-time minimum wage. I'd ask if we'd be willing to sign ex parte in order appointing the GAL with half private pay by my client and the other half county pay, at least at this time, by mom, so that we can get the GAL started. We'll need to address at a future hearing set over for addressing support so that we can respond. But I think we'd like to get both sides like to get the GAL started as soon as possible. And since that has been filed, if that would be agreeable, I can present an order ex parte for signature to that effect.
Ms. Holder?
I do agree with Mr. Baldwin. We had gone back and forth off the dock about this. I agree.
Okay. All right. I will go ahead and sign, just put cover letter and that reminds me, and that'd be fine. I'll go ahead and sign. I don't see the document here in Odyssey yet. So I'll take it what you've said.
Thank you, Judge.
Thank you.
Your Honor.
Do we have anyone else present other than Mr. Zandy? Do we have Mark Hitchcock present? Mark Hitchcock. Looked in the waiting room, not there. So with that, Mr. Zandy, any information at this point?
No, and it's somewhat unusual, Judge. He's usually very active in these proceedings. This case was filed back in the middle of June, I believe on the 19th or so. We did give him email service as well as mailed it to his last known address in Rainier, which is the home of, I believe, of his mother. Yeah, we did have a settlement conference last week in front of Commissioner Carmi, who was aware of the hearing. Mr. Hitchcock was aware of the hearing. So the fact he's not here today is somewhat surprising, considering his past involvement has been extreme, to say the least. I do think the request is made in our motion is appropriate from the information that has been provided. I think the parties do agree that the house is listed for sale with Debbie Troll. I think we're still asking for that. As far as what we do with the net proceeds, I'm just asking that those either be placed in my trust account or in an interest rearing account someplace else. I don't really care. I just want those funds to be preserved as much as possible. And that initially out of the sale proceeds that Mr. Hitchcock get current on what by my count, there's about 5 or 6 different judgments out there for attorney's fees and sanctions and costs. And there's also $1,000 that's owed to Dr. Maherd for the mental health evaluation. We would ask that upon the sale, by my math, that's about $4,100. I can certainly rein that in down to a dollar amount if necessary. But we ask that anything that's owed by Mr. Hitchcock be paid from his portion of those sales off the top.
Well, he was aware of today's hearing, was served and given notice as far as the date and time of the hearing. So with that, I did review the files and record, and based on that, number one, the home will be listed for sale through Debbie Troll. I'm not quite sure how to say her name. I believe that's at Trull. Any disputes of a material issue can be resolved by the listing agent, such as price, showing, staging, Repairs and maintenance, I'm not as, I would say, that are $500 and less. She can agree on anything more than that. The court would want it to come back before the court. Contract terms and other necessary aspects of the home sale can be resolved by Ms. Troll. The only concern I had was on repairs and maintenance. So I didn't want to see a really large amount come up and that be an issue. And then the proceeds shall be placed in the trust account, Chad Zandy, with ordered and approved distribution of any attorney's fees payable to Mr. Zandy by the husband's outstanding guardian line fees, and the husband's outstanding fees to Dr. Maher, all to be accounted for under husband's share of final distribution of funds.
Very well. And I'll have an order coming over ex parte, hopefully by the end of the day or tomorrow morning.
Okay, just make sure to note on there that he was not present.
I will do that. Thank you, Your Honor.
Thank you.
So this is a presentation of an order from your last hearing, Your Honor. There's competing proposed orders, and then there's a motion that the petitioner filed that I think is inappropriate. It asks for two sets of relief. One is a reconsideration. We can't ask for that until the order is entered. And then it asks for basically sanctions for preparing a order, the order that's before Your Honor with regards to the hearing, primarily because I didn't just unilaterally sign off on the petitioner's order, and I was out of the country basically for 2 weeks after just after our hearing. So what we need to do is enter an order from the hearing, and then I would ask the court to dismiss counsel's request beyond that.
Okay, let's go to the order first. So that's what I'm concerned about. I do have one order. Let me see who it's signed by. From Miss Ward.
And then I had sent a proposed order over, but Your Honor struck through it and indicated that it needed to be, and I had sent it as a proposed order for today's hearing, but it appears that you assume that it was being proposed ex parte, I think.
It was in the ex parte bin. That's where it got sent to. So if it doesn't have a cover letter as to what it is, sometimes that's what happens. So anyhow, so let me look at that.
And may I just briefly present as a moving party, just to clarify?
Just a second. I'm trying to just find the orders first and then. Sure. Okay. All right. So I do have the two orders now. I was trying to make sense out of what was going on. So with that, Ms. Ward, the problem is right now I've got competing orders. And the question is, which one is the court going to sign off on? And Mr. Anagnostia, looking at the one that I denied because it was in the ex parte bin. So just so you know, that's what I'm looking at there. But with that, go ahead, Ms. Ward, as to objections.
Thank you, Your Honor. So I just want to clarify that all of the findings in my order were written contemporaneously as Your Honor delivered the ruling of the court. I don't know if Your Honor had an opportunity to perhaps review the hearing video on this matter. I know it took place some time ago before you went on medical leave, but they do accurately reflect the order of the court. Counsel also acknowledged on the record that Judge Warning had previously allowed his client to keep approximately $23,000 from the business property proceeds to secure housing, and indicated to Your Honor that it hadn't been used for that purpose. As I recall, Your Honor specifically said, if your client didn't use the funds for that purpose, I just don't know what to say. I wrote down Your Honor's findings because they were very strong findings. Your Honor did use very strong language with reference to the motion that was being brought before the court. At the end of the day, in reviewing the orders, the court knows best, which reflects its ruling. But regardless of which one is adopted, I would certainly request that Your Honor keep the language that states no further funds shall be distributed from the business property proceeds prior to trial. That was a specific finding made by the court, and I ask that it remain in the order precisely because we should not have to return on this issue yet again. The matter of distributing funds from the property, which was sold in violation of the court's order, was already brought before the court twice in violation of res judicata, as Your Honor found, and we should not have to appear on this matter yet again. At the end of the day, I took the initiative to draft this order. Counsel has not historically taken the initiative to draft orders on my motions or his motions. So that's why I took the lead here. Counsel is also confusing the facts in this case. Your Honor, following at the hearing, requested that agreed orders be provided ASAP since you would be going out on medical leave. As the prevailing party, I drafted an order immediately following the hearing and provided it to counsel on June 4th, that same day. I followed up with him twice on the 7th and the 14th with no response. The issue here is not that he didn't just sign off on the order. The issue is that he didn't communicate whatsoever. He did not provide any communication to me, and I didn't get any communication until he provided a competing order in response to our motion. I notified counsel on the 14th that I would be seeking fees if we had to appear at a hearing anyway, just due to his lack of communication. His notice of unavailability was sent to me by his staff on June 18th for the 17th through the 1st, not for that 2-week period during which I was trying to correspond with him about getting a motion entered on this matter. Regarding the fees that I requested, I am requesting fees for him filing a baseless motion previously, as well as for having to appear on this matter in court. And that is because counsel's most recent motion was baseless and filed in violation of res judicata. All 4 of his requests were denied in full with very strong language, which we included in our findings. And an action is considered frivolous when it, quote, cannot be supported by any rational argument on the law or the facts. The court's findings make clear that none of the motions brought before the court could be supported on the law or the facts. Also, I needed to provide a fee statement as part of my motion for fees, which I was not able to do until after the hearing had been completed. Contrary to what counsel claims in his declaration in support of a request that the county pay him additional significant attorney fees, we are not the party requiring multiple court appearances in this matter. We have done everything possible to minimize costs and have only brought motions when there are egregious violations of court orders. These ongoing violations are just part of respondents' intransigence, which most recently includes filing a baseless motion that was also brought pursuant to a motion to shorten time. Respondent and his attorney at present have no motivation to keep costs down, and we are requesting fees to compensate my client and ensure that they will be more thoughtful in the future about what's brought before the court. Again, I'm just hopeful that Your Honor recalls this very strong findings that Your Honor issued in response to the previous motion. They are contained in the findings of the order I provided to the court.
Mr. Anagnostou?
Yes, Your Honor. I take great issue with the indication that we have brought baseless motions. We have not. So this matter was scheduled to go to trial the week of May 6th. It was unilaterally stricken by the court. Trial was stricken. We were more than willing, able, ready to go to trial. I had done all the client interview and witness interviews. We were on the trial doorsteps when the court at readiness said, unfortunately, we can't do this trial. So the trial got stricken. So the only motion that I have brought is following the striking of trial to get relief from my client, because it's the same relief my client was going to ask during trial. We're going to present all the evidence that I tried to present to Your Honor, all the bank statements showing that he hasn't had income, had statements that he had lost his contract with BP. All that's in his motion that we would have presented at trial had we gone to trial, and this motion would not have been done. So one motion to get my client relief, and I think it was an appropriate motion to get before Your Honor. The fact that you denied it, courts do that. They deny motions, and you heard all the evidence, and that was your ruling. So I understand that, but that's not being recalcitrant, or that's not being obstructionist on this. So that's where we are. We're here to present an order based on your ruling that you denied my motion. I understand that. And counsel is yet again asking for other relief. She wants you to reconsider that and find that the motion now was frivolous. You never made that finding. I don't think it was frivolous. It was, like I indicated, it was the same evidence we were hoping to present to trial. I presented in the motion. So, and then she's combined that with another motion saying that I was supposed to call her back with regards, or send her an email or something with regards to the order, when I was in the process of leaving the state for 2 weeks. You know, the local court rule is that the petitioners to prepare the order, the moving party in this case is to prepare the order, and the moving party was my client. And I prepared the order based on Your Honor's ruling, denying the motion. And I requested that order be signed, and at the other requests that are, both inappropriate because it's a motion to reconsider before an order is being entered, and secondly, claiming that I've been somehow recalcitrant and not going through our local court rule process, those requests should be denied.
Anything further, Ms. Ward?
Yes, I just want to point out that again, the reason it is very important that the findings reflect precisely the words used by Your Honor, as mine do, is because looking at those findings, you can see that in fact, you found this to be a frivolous motion, one that could not be supported on the facts or the law. One of the issues in the motion was dismissed for res judicata. That is just a basic inappropriate motion to bring before the court. And again, it was brought pursuant to a motion to shorten time. Your Honor dismissed it in its entirety with very strong language. That is why fees are appropriate in this case. The county may be paying his client's fees. My client is having to borrow money to pay hers. The fact that she had to come before the court and defend against a motion that was found to be baseless on every point is concerning, and she does deserve to be compensated. Again, as I said, a motion that cannot be supported on the law or facts meets the definition of being frivolous, which is part of the definition of intransigence and a situation in which attorney fees are warranted. Lastly, I just want to clarify again that 2 weeks went by before there was a notice of unavailability in place. During that time, Mr. Anagnostou refused to respond to any of my emails, which were simply geared at trying to get a motion entered on the baseless motion that he brought before the court. So we are now before the court again, simply because he refused to communicate with me. My client had to respond to a motion for the order to shorten time, for the motion itself, and to get the order done. And all based on a baseless motion. She does not have the funds available for this. So that is why we are asking that Your Honor hold respondent accountable, say, yes, these findings do reflect that it was baseless and fees are appropriate.
Brief reply, Your Honor.
No, I'm done.
All right.
So first off, in regard to the proposed orders, I've reviewed the orders and I find that Ms. Ward's order is appropriate. It's what I said. I certainly did not find him disabled. So with that, Mr. Anagnostou, are you okay to put approved via Zoom?
No, I'm not.
All right. In regard to the order for attorney's fees, I want to read through this. Let me just understand, Ms. Ward, I'm trying to recall, did you ask for attorney's fees on that day that this was originally argued?
I don't believe so, Your Honor. As I said, I wanted the opportunity. It's my understanding that pursuant to the rule, I need to provide a proof of costs incurred, costs and fees incurred, and I couldn't do that until the end of the hearing. I provided it contemporaneously with the motion to show the basis for fees.
So in regard to your new motion for order for attorney's fees, I'm going to deny it. I'm going to deny it in the sense that, one, we don't need if you're going to make that request, it should be made at the time of the hearing, not at the presentation, which is what we're here for. I understand Mr. Anagnostou may not have responded like you wanted him to. That's when you note it up and you present your order. So if I start ordering fees every time somebody doesn't get the response that they may be looking for, so I'm not going to be ordering those attorney's fees. So that will be denied.
Understood. Thank you, Your Honor.
Mr. Anagnostou, are you okay to put approved via Zoom on that one?
Yes, Your Honor.
We're done with that matter.
Thank you, Your Honor.
Thank you, Your Honor.
Morning, Your Honor.
Morning. So this comes on for two things. One is for an order compelling password disclosure, and the other is for spousal support and attorney's fees.
And there's one other issue with regards to the Ford Ranger.
Oh, that's right. That's
Yeah,
right.
I haven't received a response, so
I haven't either.
I wanted to address that if I could, Your Honor. Yes, so I've been, as you know, Mr. Blowers travels extensively throughout the United States. I haven't had an opportunity to speak with him until last week. As a result of that, I have not been able to provide a response. And so at this time, I'd be requesting continuance so that I can respond on behalf of my client.
Mr. Anagnostou?
Mr. Trotter could have got a hold of me prior to today. I mean, we're here ready to go. My client has incurred my fees for me to be here today. I understand the court if you want to set this over, but there should be an award of fees for the late request. I mean, I'm pretty available if Mr. Trotter would have got a hold of me.
So, Mr. Trotter, why, and is there some reason you didn't get a hold of Mr. Anagnostou before now, as well as the court, to let the court know that you'd be asking for a continuance?
I was looking to, I wanted to reach my client first so that I could make that determination. That's the only, I needed to await a response from my client.
So, Mr. Anagnostou, what I would ask is, I am going to set it over to July 30th. But just on that day, Mr. Anagnostou asked for the attorney's fees because I will be granting, not ask, I am going to grant $500 in attorney's fees for the fact that this matter's been on. You've been here waiting for this. And so I'll just grant $500 in attorney's fees for terms for the amount of time you've had to wait. And then we'll go ahead, like I said, set it over to July 30th for hearing.
Very good, John.
Okay.
Thank you, Your Honor. Thank you.
All right, that concludes the docket. Is there anyone else that believes they have something on? Okay. All right, I'll be closing out the Zoom hearing.